All right, so today we're going to be taking a deep dive into unlawful detainer eviction in California.
Oh.
Specifically, the major changes that happened in 2025.
Sounds good.
I've got a ton of information here that you sent over, a lot of frequently asked questions and some articles, and I know that you specialize in this area of the law, so
yes, I do.
I'm really excited to have you on.
Thank you so much for having me.
Yeah, of course. So for somebody who's just kind of getting their feet wet, trying to learn about this whole thing,
Sure.
what is unlawful detainer? What does that even mean?
Well, unlawful detainer is just a fancy legal term for eviction here in California.
Okay.
And it's a very specific process that a landlord has to go through to legally remove a tenant from the property.
So it's not as simple as just saying like, hey, get out.
Exactly. Not at all.
There's a whole process.
Yeah, definitely a legal dance that they have to follow.
Got it. Okay. And in 2025, there were a lot of changes to this process. So
That's right.
let's talk about some of those. One of the biggest changes I saw was the amount of time that a tenant has to respond to an eviction lawsuit.
Yes,
It used to be 5 days, right?
that's right. It was a very short timeline.
Which seems as not a lot of time
Not a lot of time at all.
to figure out what's going on and
Yeah.
lawyer up.
You're exactly right.
What is it now?
So now tenants have 10 court days to respond, or 15 if they were served by mail.
To double time.
Double the time.
Wow. So that seems like a pretty big deal.
That is a very big deal. It gives tenants much more time to understand the situation,
Right.
maybe consult with an attorney,
Yeah.
gather any evidence they might need,
Yeah.
or even just try to work things out with the landlord and avoid going to court altogether.
That makes sense.
Yeah.
So that was thanks to AB 2347. That's the bill number?
That's right. That's the bill that made that change.
Okay. Another thing that kind of jumped out at me when I was looking at this stuff was that landlords can no longer charge fees for things like posting the eviction notices.
Yeah.
Like the 3-day notice to pay rent or quit. What's the deal with that?
So those fees were often considered kind of like junk fees or just ways for landlords to tack on additional costs to tenants who are already in a difficult situation.
Oh.
They weren't really covering any significant expenses for the landlord.
Right?
So lawmakers decided to eliminate them to kind of protect tenants from those unnecessary financial burdens.
That makes sense.
Yeah.
And have you seen that? Has that had a significant impact?
I'd say so. You know, every little bit helps, especially when you're facing something as stressful as an eviction.
Yeah, for sure.
So getting rid of those extra fees can really alleviate some of the financial pressure.
Yeah, absolutely.
Yeah.
Now let's talk about another area where there were some pretty big changes, and that's security deposits.
Right.
There's this new emphasis on transparency when it comes to security deposits.
Absolutely.
So tell me a little bit about that.
Well, before 2025, landlords didn't always have to provide really detailed explanations for why they were deducting from security deposits. But now they're required to provide photographic evidence and descriptions for any deductions they make.
So it can't just be like, oh, there was damage, here's $300.
Right, exactly. It has to be very specific.
Right.
And they have to be able to back it up with photos.
And when did this go into effect? Was it all at once or?
It was a phased rollout.
Okay.
So starting April 1st, 2025, landlords have to take photos after the tenant moves out
Okay.
and after any repairs are made. And then by July 1st, 2025, they also have to take photos before the tenant moves in.
Got it.
So it gives both sides a clear record of the condition of the property.
That makes sense.
Okay.
Now, this next one is a really interesting one, and I think a really positive change for tenants.
Okay.
It's the option for tenants to have their positive rent payment history reported to credit bureaus.
Yes.
So talk to me about this, because that seems like a big win for tenants.
It's a huge win because for a long time, paying your rent on time didn't really help you build credit,
Right.
which put renters at a disadvantage. But this new provision aims to change that.
So now if you pay your rent on time, it can actually help improve your credit score.
Exactly. It can help tenants establish credit or boost their existing score,
That's huge.
which is really important for things like getting loans, qualifying for a mortgage, or even renting a new place.
And I know that there's a fee cap on this as well, right? So landlords can't just charge.
That's correct. There's a cap of $10 per month that landlords can charge for this service.
Okay.
Existing tenants should have been offered this option by April 1st, 2025, and it's now a standard requirement for all new leases at signing.
So even if you are going through an eviction and you've been paying your rent on time up until that point, you could still have that positive payment history reported.
Exactly, and that can be really helpful in securing future housing.
That's amazing. Okay, so we're seeing some really big changes here, trying to create a more balanced system between landlords and tenants.
Absolutely. It's a step in the right direction.
All right, so let's shift gears a little bit and talk about some of the other protections that are in place for tenants. One thing that really stood out to me was the enhanced protections for tenants who are experiencing domestic violence.
Yes.
So tell me a little bit about those.
So under the new law, tenants who are victims of domestic violence, sexual assault, or stalking have the right to request immediate lock changes for their safety.
Okay.
And landlords are required to comply within 24 hours.
And what kind of documentation do they have to provide for that?
Usually a copy of a restraining order police report
Okay.
or other official documentation that supports their situation would be sufficient.
Okay.
And this is a free service for the tenant.
Okay, got it.
The cost cannot be passed on to the tenant.
Okay.
It's all about ensuring their safety and well-being without adding any further financial burden.
Yeah, that makes sense. Now, one last thing before we move on. I saw some stuff about application fees.
Right.
And there's some changes there as well. I know application fees can be a pain point,
They definitely can.
especially if you're applying to a lot of places.
Yeah.
So what are some of the key changes that tenants should be aware of?
Well, landlords can now only charge an application fee if a unit is actually available or will be available soon.
Okay.
They also have to be upfront about their screening criteria
Okay.
and provide refunds if an application is rejected for certain reasons, like if the applicant's credit report doesn't meet the landlord's standards.
So it's about making sure that tenants aren't being taken advantage of.
Exactly. It's about promoting fairness and transparency in the application process.
Great. So it seems like overall, these changes that went into effect in 2025 really are trying to
They are.
level the playing field a little bit,
Absolutely.
create more protections for tenants.
Yeah.
But I'm curious from your perspective, do you think these changes also offer any advantages for landlords?
You know, they actually do in some ways.
Really?
Yeah, for example, that extended response time that we talked about might seem like it only benefits tenants,
Right.
but it also gives landlords more time to prepare their case, gather evidence, and potentially even work towards an amicable resolution with the tenant outside of court.
So it kind of streamlines the process.
Exactly. A more organized process can benefit everyone involved.
That makes a lot of sense.
Yeah.
So it's not necessarily just one-sided?
No, not at all.
All right, so speaking of the legal process, can you walk us through
Sure.
what are the typical steps involved in an unlawful detainer case? Like, from a tenant's perspective, what should they expect if they're facing eviction?
Okay, so the first step is the landlord has to serve the tenant with a written notice.
Okay.
And this could be a 3-day notice to pay rent or quit, a 60-day notice to vacate, or some other type of notice depending on the reason for the eviction.
So that's like the first official step.
Exactly. It's a formal notification that there's an issue,
Yeah.
and it outlines what the tenant needs to do to fix it.
And if they don't comply with that notice, then what happens?
Then the landlord can file an unlawful detainer lawsuit with the court.
And at that point, the tenant has that extended response time we talk about, right?
That's right. They have 10 court days, or 15 if served by mail, to file a response to the lawsuit.
And what should a tenant do during that time? What are the most important steps to take?
Honestly, the best thing a tenant can do is contact an attorney immediately.
Right.
A qualified attorney can really help them understand their rights, analyze the situation,
Hey.
and figure out the best course of action.
So don't try to go it alone.
No, definitely not. Eviction law is very complex.
Okay.
And having an expert on your side can make all the difference.
So once the tenant files a response, what typically happens next? Do they go straight to court?
Not always. Sometimes there's a period of negotiation between the landlord and tenant,
Okay.
sometimes involving their attorneys to try to reach a settlement,
Okay.
like maybe a payment plan or an agreement for the tenant to move out by a certain date.
So there's room for compromise.
Absolutely. And in fact, a lot of cases are actually resolved through negotiation without ever going to trial.
That's good to know.
Mm.
But if a settlement can't be reached, then they would have a trial.
That's right. At trial, both sides present their evidence and arguments, and a judge makes a ruling.
And if the judge rules in favor of the landlord, then
Then the judge will issue an order for the tenant to be evicted, and that order is carried out by the sheriff.
okay. So it is a serious process,
It is.
but it's good to know that tenants have rights
absolutely
throughout that process.
every step of the way.
Now I want to touch on something that I think is really important, and that's the emotional impact of facing eviction.
Yes.
I can't imagine how stressful that must be.
It's incredibly stressful. You know, losing your home is one of the most difficult experiences anyone can go through.
Yeah.
It impacts every aspect of your life, your sense of security, your finances, your mental health.
So what advice would you give to someone who's going through that right now? What resources or support systems are out there?
First and foremost, I would say Remember that you're not alone. It's really important to reach out for support, whether it's from family, friends, or community organizations. There are also a lot of resources available to help tenants facing eviction.
Like what?
Well, local legal aid societies offer free or low-cost legal services for those who qualify.
Yeah.
And many cities and counties have housing rights organizations that can provide guidance and support.
So there are people out there who can help.
Absolutely, don't give up hope.
That's good to know.
There are steps you can take and help is available.
All right, so we've talked a lot about non-payment of rent
Right.
as a common reason for evictions. But what are some other reasons that a landlord might file an unlawful detainer lawsuit?
Well, lease violations are another big one.
Like what kind of lease violations?
Things like unauthorized pets, property damage, engaging in illegal activities on the property.
So basically anything that violates the terms of that lease agreement.
Exactly. Both landlords and tenants have to abide by the terms of the lease, and violations can lead to eviction. It's important for tenants to really read and understand their lease agreements.
Yeah.
And if anything is unclear, don't hesitate to ask the landlord for clarification.
Good advice.
Yeah.
Now, we touched on this earlier, but I want to go a little deeper into the protections for tenants experiencing domestic violence.
Okay.
Specifically, the right to break a lease early without penalty.
Right.
Can you explain how that works in practice?
So a tenant who's experiencing domestic violence, sexual assault, or stalking can provide documentation of the abuse to their landlord, along with written notice that they're terminating the lease.
Okay.
And this releases them from their lease obligations so they can leave without being penalized.
Now, what kind of documentation do they need?
A copy of a restraining order police report or a letter from a qualified professional, like a therapist or social worker, is usually sufficient.
So it's really about making sure that they can get out of a dangerous situation safely.
Exactly. It prioritizes the safety and well-being of the tenant.
That's great. Now let's circle back to the option for tenants to have their positive rent payment history reported to credit bureaus.
Sure.
We talked about the benefits, but are there any potential drawbacks that tenants should be aware of?
Well, some tenant advocates are concerned that this option could be used as leverage by landlords to pressure tenants into accepting rent increases.
Oh, so?
For example, a landlord might say to a tenant, "Hey, I see you've been paying your rent on time, which is great. But if you want me to keep reporting that to the credit bureau, you'll need to agree to this rent increase."
Oh, wow.
So it's something to be aware of.
Yeah.
And it's important for tenants to know their rights and not be afraid to push back against unfair practices.
So it's a good thing, but it's something to be approached with caution.
Exactly. Knowledge is power, and informed tenants are better equipped to navigate these situations.
All right, so we've covered a lot of ground here.
We have.
I think it's time to start wrapping up this deep dive. But before we do, I want to ask you, what's your single most important piece of advice for tenants facing the possibility of eviction?
Don't panic. I know it's scary, but staying calm and focusing on your options is crucial.
Okay, easier said than done, I'm sure.
It is, but it's important.
So what's the first thing someone should do if they receive an eviction notice?
Seek legal counsel as soon as possible. An attorney who specializes in tenant rights can assess the situation, explain your rights, and guide you through the process.
So don't try to handle it on your own.
Exactly. Get professional help.
All right, and before we go, any final thoughts, any key takeaways for our listeners?
Yes. The 2025 changes to California's eviction laws are significant, and they're designed to protect tenants. However, navigating these laws can be tricky, so it's always best to seek professional advice if you find yourself facing eviction.
Okay.
Knowledge is power, so stay informed and know your rights.
That's a great note to end on. Thank you so much for sharing your expertise with us today.
It was my pleasure.
And to our listeners, stay tuned because in part 2 of our deep dive, we're going to be talking more about the eviction process itself and some of the specific legal strategies that tenants can use to protect themselves.
Looking forward to it.
So don't go anywhere. We'll be right back after a quick break. Welcome back to the deep dive. We're continuing our conversation about unlawful detainer eviction in California and all the changes that happened in 2025.
Right, it's a whole new ballgame out there.
Exactly, and we're lucky to have you here to help us break it all down.
Happy to be here.
So before the break, we were talking about the importance of seeking legal counsel if you're facing eviction. And I think that's a really crucial point to emphasize because this stuff is complicated.
It can be very nuanced.
Right, and it seems like having an expert on your side can really make a difference.
It really can. A good attorney can help you understand your rights, analyze the situation, and come up with the best strategy for your specific case.
So let's talk about that strategy. What are some of the legal defenses that tenants can use if they're facing an eviction lawsuit?
Well, there are quite a few defenses available depending on the circumstances of the case.
Okay.
One common defense is that the landlord didn't follow the proper eviction procedures.
Like what kind of procedures?
Well, for example, the landlord has to serve the tenant with the correct notices.
Right.
And those notices have to be very specific. And if the landlord messes up any part of that process, it could be grounds for dismissal.
So it's not just about whether the tenant did something wrong. It's also about whether the landlord followed all the rules.
Exactly. The landlord has to dot their I's and cross their T's.
Got it. What are some other common defenses?
Another common defense is that the eviction is retaliatory.
What does that mean?
It means that the landlord is trying to evict the tenant for something other than a legitimate reason, like non-payment of rent or lease violations.
Okay.
Maybe the tenant has complained about habitability issues or requested repairs.
Right.
And the landlord is retaliating by trying to evict them.
So that's not allowed.
Nope. It's illegal in California to evict a tenant in retaliation for exercising their legal rights.
That's good to know. Are there any other defenses that you see come up frequently?
Yeah. Another one is breach of the warranty of habitability.
What is that?
So in California, landlords have a legal duty to provide tenants with a habitable dwelling.
Okay.
That means it has to be safe and sanitary and have basic amenities like running water and heat.
Right.
If the rental unit has serious problems that affect the tenant's health and safety and the landlord fails to fix them, the tenant might have grounds to break the lease or even withhold rent.
So the tenant doesn't have to just put up with a substandard living situation.
Exactly. They have rights.
And if the landlord tries to evict them for withholding rent because of habitability issues, that could be a defense.
Right. The tenant can argue that the landlord is in breach of the warranty of habitability, and that's why they didn't pay rent.
So it's really important for tenants to document any problems with their rental unit.
Absolutely. Take photos, keep records of communication with the landlord.
Yeah.
All of that can be valuable evidence if you end up in court.
Now, you mentioned earlier that sometimes cases can be resolved through negotiation without going to trial.
Right.
Can you talk a little bit more about that process? What does that typically look like?
Well, it usually involves both sides coming together with their attorneys, if they have them, to try to reach a mutually agreeable solution.
And what are some examples of solutions that might come out of that?
It could be a payment plan if the eviction is based on non-payment of rent.
Okay.
Or maybe the tenant agrees to move out by a certain date in exchange for the landlord dropping the case.
Right.
There are a lot of possibilities.
So it's really about finding a compromise that works for both sides.
Exactly. And it can save everyone a lot of time, money, and stress.
Yeah, I bet. So if you're facing an eviction, it's definitely worth exploring negotiation as an option.
Definitely. It's often the best outcome for everyone involved.
Now, I know this is kind of a broad question, but what are some general tips that you would give to tenants who are trying to avoid eviction in the first place?
Sure. Well, first and foremost, communication is key. If you're having trouble paying rent or if there's an issue with the unit, talk to your landlord as soon as possible.
Right.
Don't ignore the problem or hope it goes away.
Yeah.
The sooner you communicate, the better the chance of finding a solution.
That makes sense. What else?
Another important tip is to know your rights and responsibilities as a tenant. Familiarize yourself with California's tenant laws and make sure you understand your lease agreement.
Right.
That way you'll be better prepared to advocate for yourself if there's a problem.
And I imagine keeping good records is also important.
Absolutely. Keep copies of your lease agreement, rent receipts, any communication with your landlord.
Yeah.
You never know when you might need that documentation.
So it's all about being proactive and informed.
Exactly. Knowledge is power.
Now, I want to circle back to something you mentioned earlier about retaliatory evictions.
Okay.
Can you give some specific examples of what might be considered retaliatory behavior by a landlord?
Sure. So let's say a tenant reports a health and safety violation to the city.
Okay.
Like a broken smoke detector or mold in the bathroom.
Right.
And then the landlord tries to evict them shortly after that.
That seems pretty suspicious.
Yeah, that could be seen as retaliation.
Oh, okay.
Or maybe a tenant requests repairs.
Yeah.
And the landlord refuses to make them and then tries to evict the tenant for complaining.
So basically, anytime a tenant exercises their legal rights and then the landlord tries to punish them for it.
Exactly. It's a violation of the law.
Now, what if a tenant is facing eviction and they're not sure if it's retaliatory or not? What should they do?
Well, again, the best advice is to talk to an attorney.
Right.
An attorney can help them assess the situation and determine if there's evidence of retaliation.
And if there is evidence of retaliation, what can the tenant do?
They can use that as a defense against the eviction. and potentially even sue the landlord for damages.
So it's not just about stopping the eviction, it's also about holding the landlord accountable.
Right. It's about protecting tenants' rights and making sure they're not being unfairly targeted.
That's really important. Now, I know we've been focusing a lot on the legal side of things, but I think it's also important to acknowledge the human side of this issue.
Absolutely.
Facing eviction can be a very traumatic experience.
It really can.
It can be emotionally draining, financially devastating.
Yeah, it can upend your entire life.
Right. So what advice would you give to tenants who are struggling to cope with the emotional stress of this situation?
Well, first of all, I would say it's okay to feel overwhelmed and scared.
Yeah.
It's a natural reaction to a very difficult situation. Don't be afraid to reach out for support, whether it's from family, friends, a therapist, or a community organization.
So it's really important to remember that you're not alone.
Exactly. There are people who care about you and want to help.
And in addition to emotional support, are there any practical resources that you would recommend for tenants facing eviction?
Yeah, definitely. As we talked about earlier, legal aid societies can provide free or low-cost legal assistance.
Okay.
And there are also housing rights organizations in many communities that can offer guidance and resources.
So there are options out there.
Absolutely. There is help available.
That's good to know. All right. So we've covered a lot of ground here today.
We have.
I think we've given our listeners a really good overview of unlawful detainer eviction in California.
I hope so.
But I'm sure some people are still wondering, okay, this is all great information, but what does this mean for me personally?
Right.
So let's get a little bit more specific. Now, I know you can't give legal advice.
Of course not.
But can you give some hypothetical scenarios to illustrate how these 2025 changes might play out in real life?
Sure, I can do that. Let's start with a scenario involving the extended response time.
Okay.
So imagine a tenant named Sarah. She's been struggling financially and is a little behind on rent.
Okay.
She receives a 3-day notice to pay rent or quit from her landlord.
Uh-oh.
Now, under the old law, Sarah would only have 5 days to come up with the money or face eviction.
Which is not a lot of time.
No, it's not. But thanks to the 2025 changes, Sarah now has 10 days to respond. That extra time could be crucial. She might be able to get a loan from a family member.
Right.
Or work out a payment plan with her landlord.
Or even just find a new place to live.
Exactly. It gives her more breathing room and a better chance of avoiding eviction.
That makes sense.
Yeah.
Okay, let's do another scenario. What about one involving the new security deposit rules?
All right, so this time, let's say we have a tenant named David. He moves out of his apartment after a year.
Okay.
And his landlord withholds a significant portion of his security deposit, claiming there's damage to the unit. Now, under the old rules, David might have had a hard time disputing those deductions because the landlord didn't have to provide much evidence.
Right.
But thanks to the 2025 changes, the landlord is now required to provide photographic evidence and descriptions of any damages.
Oh, so David can actually see what the landlord is talking about.
Exactly. And if the photos don't support the landlord's claims, David has a much stronger case to get his security deposit back.
So it's all about transparency and accountability.
Right? It levels the playing field and protects tenants from unfair deductions.
I like it. Okay, one more scenario. How about one involving the credit reporting option?
All right, so let's say we have a young woman named Maria. She's just starting out and doesn't have much credit history. She's renting her first apartment, and her landlord offers her the option to have her positive rent payments reported to credit bureaus.
Okay.
Maria decides to take advantage of this option, and because she pays her rent on time every month,
good for her.
Her credit score starts to improve. This makes it easier for her to qualify for a car loan, get a credit card, and eventually even buy her own home.
Wow, so it can really have a long-term impact.
It definitely can. It helps tenants build credit and achieve their financial goals.
That's awesome. All right, so we've covered a lot of ground here. I think it's time to start wrapping up this deep dive. But before we do, I want to make sure our listeners know where they go to get more information.
Absolutely.
So you're with the Martinez Law Center in Santa Ana, California.
That's right.
Tell us a little bit about your firm and the services you provide.
Well, the Martinez Law Center specializes in representing tenants in eviction cases.
Okay.
We're passionate about fighting for tenants' rights and making sure they have access to quality legal representation.
And you serve clients throughout Southern California, right?
We do. We have offices in Santa Ana, which is in Orange County,
right.
And we also serve clients in Riverside, San Diego, and Los Angeles counties.
So if you're a tenant facing eviction in Southern California, the Martinez Law Center is a great resource.
We are.
How can listeners get in touch with you?
The best way to reach us is through our website, Martinez Law Center CASEM.
Perfect. We'll be sure to include that link in the show notes as well.
Great.
All right. Well, thank you so much for joining us today.
Yeah.
Your expertise has been invaluable.
It was my pleasure.
And to all our listeners out there, stay informed, stay curious, and know your rights.
Yes. Know your rights.
We'll see you next time on The Deep Dive. All right. So we're back, and we've been talking all about unlawful detainer evictions in California.
Yes, we have.
With a big focus on those changes in 2025.
Big changes for sure.
And I want to kind of shift gears a little bit now and talk about the bigger picture.
Okay.
Like how these changes might impact the rental market in California as a whole.
Yeah.
Because anytime there's a major shift in the laws, you got to wonder what the ripple effects are going to be, right?
Exactly. Anytime you're changing the dynamics between landlords and tenants,
yeah,
there are going to be consequences.
So what are some of the potential consequences that you're seeing or that you're anticipating?
Well, one concern is that these increased protections for tenants might discourage some landlords from renting out their properties.
Oh, so it might make it less appealing.
Right, exactly.
To be a landlord.
If the perceived risks are higher, they might say, hey, this isn't worth it anymore.
And if fewer people are willing to be landlords, then what happens?
Then you could end up with a shortage of available rental units, which could drive up prices.
Classic supply and demand.
That's right.
So tenants might have more protections, but it might also be harder to find a place to live.
Exactly. And more expensive.
Yeah, that's a tough trade-off.
It is.
But are there any potential upsides to these changes? Like maybe something that would actually benefit landlords in the long run?
There could be.
Really?
Some people argue that these changes might actually lead to a more stable and reliable tenant pool.
How so?
Well, if tenants feel more secure in their rights, they might be less likely to default on rent or cause problems.
That makes sense.
Longer tenancies, fewer evictions.
Yeah.
That could be appealing to landlords.
So even though there are more responsibilities on the landlord side now, there could be some benefits in terms of like peace of mind and just having more stable tenants.
Exactly. It's all about finding that balance.
Right. So it's really too early to say definitively what the long-term impact is going to be.
Yeah, it's going to take some time to see how everything shakes out.
But it's definitely something to keep an eye on.
Absolutely. It's a dynamic situation.
So let's wrap up this deep dive with some key takeaways for our listeners. What are the most important things you want people to remember?
Well, first and foremost, I want to emphasize that these 2025 changes to California's eviction laws are a big deal.
They are.
They really do provide significant new protections for tenants.
And we talked about a lot of those specific protections today, right?
We did the extended response time, the ban on junk fees, the stricter security deposit rules, the enhanced protections for victims of domestic violence. It's a lot to take in.
It's all good stuff.
It is. It's a step in the right direction towards a more equitable rental landscape.
Absolutely. And I think another big takeaway from our conversation is the importance of communication.
Oh, yeah. Communication is key.
Whether it's a tenant reaching out to their landlord about a problem or a landlord being upfront with their tenants about their expectations.
Right.
Open and honest dialogue can often prevent small issues from escalating into big legal battles.
It's so much easier to resolve things amicably when everyone is on the same page.
And if things do escalate to the point of eviction, we cannot stress this enough, get legal help.
Absolutely. Seek legal counsel as soon as possible.
An attorney who specializes in tenant rights can help you understand your rights, navigate the process, and protect your interests.
And don't be afraid to ask for help.
Right.
There are resources out there, legal aid societies, housing rights organizations. They're there to support you.
So even though this whole topic can be kind of overwhelming and intimidating,
it can be.
there are people and organizations that can help you through it.
Exactly. You don't have to face this alone.
That's a really important message to leave our listeners with. So thank you again for sharing your expertise with us today.
It was my pleasure. Thanks for having me.
And to all our listeners out there, stay informed, stay curious, and most importantly, know your rights.
Know your rights.
Thanks for tuning into The Deep Dive. We'll see you next time.
Call now 714-442-9741. Thank you.